Never rains but it pours, does it? I've just been waiting for something to come in because I just had a little bit to say about professional standards. Because I would say there's been emails flying back and forward, but of course I never answer you. So there's been emails flying in their direction. I said that obviously all my previous complaints must be reopened because on the 18th of May the police proved that they'd broken the law on all previous occasions because they had no warrant and they just wandered off because there was nothing they could do. Still don't know what it's about, to be sure. We're still assuming the assault charge, or they made up assault charge. They've said they can't reopen all my complaints because it's vexatious and oppressive, and they've gone to the trouble of listing them all, even though they're not going to open them up again. Well, thank you. That's a very handy correlation for me to refer to instead of digging through my files, professional standards. So that's probably going to save me a lot of time in the future. Apart from my current complaint, so I'm assuming that this letter doesn't cover that, because that's live. They do like to make things up because they said the complainant states that a large amount of officers attended the complainant's premises. When I said up to 5, I didn't say a large amount at all. I know paperwork was supposed to, well, I've got that bit right. Apparently, it's considered to reopen the complaints would be a misuse and manipulation of the complaints procedure. Complaints that you never fucking answered satisfactorily, anyway. You just said things like, everything was done to make me know that I was under arrest or something, when your officer said, "You're got, mate," and all that shit. The fact that no new information has been provided. Do you need any when your officers go around saying, "You're got, mate," instead of "you have the right to remain silent," and all that shit that it's supposed to say? Do you know what I mean? Result in the harsh, I love this bit, if they reopen the complaints, it would result in the harsh and wrongful treatment of the persons complained about, and the complaints are being made with the intention to vex, worry, annoy or embarrass the organisation and members of staff subject to the previous complaints. Well, quite right, really, because you're a bunch of lying bastards, and I think that's been proven time and again on this channel. I love it, Kent Police. They won't fucking give up, will they? Now, this is honestly, since I did the video, speeding fines are unlawful, this is the first I've heard of them, and there's a reason why I mentioned that. You're supposed to start with the yellow form where it tells you to plead guilty, basically. So we'll just ignore that. So what they're charging me with, right? Suddenly the speeding charge doesn't matter anymore. Now it's failed to give information relating to the identification of the driver. Well, I shall repeat myself. I said you had those details because you'd sent nothing to my house and I did not dispute those details. Therefore, I did not fail to give identification of the driver in the least. So you're just making this shit up now. You Freemason fucking pieces of shit. In fact, I might even tag you in this on Twitter if I can find your hashtag. Oh look, if you plead guilty using the notice, you'll usually get a 33% reduction on any fine. So they're already going to fine you. That just explains the charge. On behalf of the Chief Constable of Kent Police. Not the Chief Constable himself. Or herself. I don't know. I don't know if it's a man or a lady down in Kent. So this is why I mentioned this bit before. They've done a whole thing of what they've done, what's happened, right? 11th of February, speeding offence detected. 15th of February, notice of intended prosecution. 18th of February, Section 172 response received providing the information of the vehicle was in the possession of Mr. Paul Harrison Dacres. So how does that not identify the driver? Well, did you think I just fucking lent it to someone or something, do you? 26th of March, unsigned letter received headed Mr. Paul Dacres stating, in part, there is no legal requirement for signing this document on the basis it would be to my financial detriment and against my will. There is no need for me to fill anything in. Well, I either choose certain bits, don't you? As I do not recognise nor am required to comply with acts and statutes. Now, here we go, 23rd of May. Letter sent to Mr. Dacres explaining the matter would be sent for the consideration of the single justice procedure, which is what all this shit is. Funnily enough, I didn't get that. So I think you're fucking lying. Decision made to prosecute at court as no driver's details confirmed. Well, they were confirmed because you were told he was driving the truck in the first place. They don't need to be reconfirmed. Not very bright with the English, are they? Right, don't know what that is. A witness statement from staff 4654554 Taylor. Requirement under the Section 172 of the Road Traffic Act 1988 to provide information relating to the identity of the driver of a vehicle sent to the defendant. No driver details have been provided. Well, guess they were, because that's how you knew to send them to my house. Because you were given my name and address, because I was driving. You fucking wombats. Fucking shit are they coming out with here, do you know what I mean? What does it again? So they've lied about sending one letter out already. And that's just fucking incomes and outgoings expenditure. Yeah, I'll just give you my fucking passcode to my bank account, shall I? Well, you have fun having a little made-up court hearing, guys. Because for a start, the car's in for MOT and it's just cost me 800 quid, so I'm skint until Christmas anyway. I shan't be attending or confirming my non-attendance. And there's your envelope. Gone as well. That's what I think of that. Right. Cracking start to the weekend, I say. See you all later.